Hello again, friends. Welcome to session 2B. I'm thrilled to introduce our next speaker and longstanding friend of MRA, Mr. Gary Clark, who will present performance management and documentation. Mr. Gary Clark is a partner at Corals and Brady. He focuses on all areas of labor and employment law and provides day-to-day counsel on employment matters for national and regional clients with a results-oriented approach. Gary emphasizes crafting creative legal solutions to further business objectives and proactively anticipates what's coming around the corner. Gary, I know this isn't your first rodeo with us, but I want to welcome you again and say thanks so much for being here today. So I'm going to turn it over to you.
Thank you, Andrew. I really appreciate it. I'm really glad to be here and really glad to be talking about the presentation that we're going to do today. I know performance management is something that is always in demand. People always have lots of questions, always looking for help, and especially in the HR realm, what I see is I have a lot of HR people call me up and just say, hey, can you just help? I've got people that they don't do any performance management. Then they come to me and they want to terminate people immediately with no documentation. Please help me explain how that we can get people to buy into this. So hopefully that's what this presentation is. The whole idea is, can I give you the toolkit and some of the basics to help improve performance management in your organization? One of the things is this is a great presentation when it's interactive. So I would love questions, and any questions I can see that would be wonderful. That would help. Let's see. I don't have slide control right now, so that's the one thing I'm looking at. I'm not able to do it. Oh, here we go. There we go. All right. So what here are some of the things we're going to talk about today. And things we're going to talk about is, let's talk about a general strategic approach, the tools to manage employee performance, best practices, get a better understanding of when people need to report to their manager or HR, and really kind of improve familiarity with company policy, procedures, and guidelines, and impress upon you the importance of being familiar with those. Again, as I said, if there are questions, this is a presentation that sometimes works best with specific questions. And I've noticed people may not always like the answers. I gave this presentation before, and I've had people sometimes ask a question about, well, can we just terminate people without performance management? And I had to sit and say, well, you can, but you might not like the consequences. So with that, so one of the first things we always have to talk about is why it's so important to manage performance. And why is it? It's because we have at-will employment generally. You got to understand that background as far as what we're looking at. And so what does that mean? It basically means people can be terminated for any reason at all whatsoever, as long as it's not an unlawful reason. So with that in mind, why is documentation important? When do we need to investigate if it's a conduct issue or if there's a dispute regarding performance? We're going to talk about that. And then we'll talk a little bit about how to conduct a disciplinary termination meeting and some common mistakes and some common best practices to go with this. So as I was saying, what does at will mean? It means the employment relationship can be terminated at any time without advance notice for any reason, good or bad, as long as the reason is not one prohibited by law. And what does that mean? That means you can terminate someone because they don't like strawberry ice cream, right? You can terminate at will employment for any reason, good or bad. So if someone doesn't like strawberry ice cream, they're out of it here. They're out of the organization. But you cannot terminate someone because of their race, their gender, their national origin, because they opposed a practice that they thought was in violation of public policy. There's lots of limitations that we're going to talk a little bit about and that you have to be familiar with. The other way that at-will employment can be limited is by contracts. Now, I see this a lot less than I did 10, 20 years ago, where it seemed like more people had contracts. But that's the first question I always ask when we're dealing with a termination decision. And that is, is there a contract that limits our ability to terminate someone for at will? Does it provide that they get 6 months of severance if they're terminated? Does it say the individual can only be terminated for specific reasons, right? These are things we need to know. These are all things that we need to know in order to make a termination decision. And then you're also going to want to make sure that you're acting consistently with your handbook. You're acting consistently with your policies, in the sense that, you know, to the extent, if you're an employer and someone's going to argue that the termination reason was unlawful, that it was illegal, whether it was based on race, gender, sexual orientation, whatever it may have been, they're going to look to ways that you act inconsistent, right? Inconsistencies to suggest that the real reason's not what you said it was. And one thing they look at for that is if you've got a handbook that promises certain protections or certain processes will be followed in all disciplinary decisions, and you don't follow those processes, that can come back to bite you. That can be something that is used to prove pretext, that maybe the reason you gave is not the real reason. And examples I'll give would be, you know, some handbooks occasionally say we will follow progressive discipline in all circumstances. Well, that doesn't allow you to jump immediately to termination if that's what your handbook says. So you need to get that handbook fixed. Similarly, if there are promises of continued employment and here are the only reasons that employment will ever be broken, that too would be something that you'd have to see if that's in the handbook and make sure you're compliant with that. All right. And I have lost slide control again. I'm trying to advance this and I'm unable to advance it. So if there's anyone listening at the time, let's see what we can do with that. All right. There we go. Got it back. And so we're dealing with, so here are some examples for things that take you out of the at-will realm. And these are reasons that can never be, these reasons can never be a reason for termination because they're unlawful. We have laws that say we do not believe that people should be terminated for any of these reasons. And if you terminate someone or take an adverse employment decision against them for one of these reasons, you're going to be in violation of the law. And, you know, some states, Illinois is one, is arrest record, right? That number of states that are prohibiting arrest record discrimination is rapidly increasing. And it's becoming much more common than it was maybe 5 years ago on a national level. Whistleblower retaliation. Someone complains about someone complains and says your accounting group is committing fraud and hiding assets to try and make performance look better than it really is. That would be, you can't terminate someone to retaliate against them for that. Sexual orientation, gender identity. In a lot of states, off-duty marijuana use can be is a protected category. Disability and religion is one that's become much more common recently for the reason that with, you know, going through COVID-19 and vaccinations and mandatory vaccination policies. And I see we do have a question about performance improvement plans, and I will say we will absolutely cover performance improvement plans today. So we'll definitely get to that. All right. I'm not sure. I've lost control of the slides again.
Hey, Gary, for the slides, just click once into the window and you have slide control. If you click out of that window, you lose it. So just stay clicked in.
Got it. Okay, I understand. I figured it was a user error, so appreciate that. So here's a chart that's a little dated, but what it has is it's talking about all the various ways that adverse employment decision or termination can be unlawful. and violate the law. And, some of these are not true in every single state, but by and large, it's increased to the point that these are true for most states at this point. All right. So what are some of the guidelines we want to talk about to avoid the appearance of, disparate treatment or retaliatory treatment, discrimination? So what are some of the most important lessons, right? And these are going to be questions that I ask for every time someone asks me for my advice on a termination. So we got to apply all rules and standards equally to everyone. Don't make exceptions. There is no good guy exception, right? The people saying, hey, I know we've terminated other people for getting in fights, but Jim had a really bad day and he's an incredible worker. And, we really want to cut an exception for him. And, that's fine if you do that, but just understand that you've made your life harder in future cases where you're terminating people for fights, because they're going to point out that you don't always enforce this rule. And they're going to look at, well, what was Jim's race? And is it different from the next person's race? And if so, that's going to be evidence to prove race discrimination. So that's something, give consistent messages and candid appraisals. So here next, always hear an employee's side of the story before taking action against him, her. And that one seems common sense for most people, but I got to admit, it sometimes gets neglected. And I get phone calls to approve a termination where nobody's ever talked to the individual to find out what their side of the story is. And, it may be an instance where the individual was slurring their words and appeared to be under the influence of something, but nobody tested them. Okay. And nobody's asked them, right? Because what if we find out the individual's on medication and the doctor changed it and that was an adverse medication reaction? That's something you need to know before you make a termination decision. Similarly, if we have someone who's talking about for time card fraud, and they clocked in someone else, done. Well, let's ask them at least first what's going on, because what if we find out their supervisor told them to clock someone else in? Well, that may not excuse it, but that's something we need to know for making our decision and addressing this with the supervisor. It's just one of those things that if you don't even get the employee's side of the story, what you're going to find is it just really looks like it was a rush decision that didn't care about what the facts actually were. And if the employee wants to argue that this was because of their race, their gender, national origin, whatever it may be, they're going to have some evidence to support that. When you're warning employees, explain, articulate the disciplinary decision to the employee. Make sure they understand it. Make sure that they understand that future instances of such conduct will result in termination. Make sure they understand the seriousness of the situation. Again, we don't make decisions based on subjective feelings about people, and we avoid any reference to class or protected activity in all write-ups in this. And for instance, you don't do a write-up that says, I have evidence of this, I've witnessed all of this, this proves that I didn't act on any discriminatory intent, right? That's such a defensive write-up that I look at that and I go, well, wait, why are we even talking about discrimination in this one? So, all right, just checking the questions to see if there's some that are real general that we could share with everybody. I have a lot on off-duty marijuana use. We could spend a whole hour talking about the individual state laws on marijuana use and off-duty and testing and reasonable suspicion and all those things. So that's not something we'll probably be able to get into today. Suffice it to say that that's one where you really want to make sure you've investigated fully before making a decision, because there are, and then you're going to want to have talked to legal counsel about that one. All right. So why do documents matter? And one of the goals here for me is I litigate a lot. And as someone who litigates a lot, I see these things on the back end after whatever investigation's been done, whatever documentation's been created, whatever decision was made. And seeing these on the back end I will say that there's lots of things I can point out today that will make it a much harder case to defend and I won't call them mistakes, but things where you don't put yourself on the best foot for defending the decision. And I would say one of the biggest is a complete lack of documentation. So if someone was a poor performer and, it's been going on for 6 months or for a year, or they were continually late, or they were continually insubordinate and we just got tired of it, and that's the termination reason, I'm going to always want to ask, see, let me see your documentation. And if I get back, we don't have any. Well, that makes it look like it's not a real issue, because was this really an important issue if it's been going on for a year and it never rose to the level that we thought it was worth documenting, that we sat down with the employee, we talked with them, and we created a document? It makes us look like we're not being truthful on this one, to the extent that we are saying it was a big issue and we couldn't take it anymore, but it was never important enough to sit down and meet with the employee and create documentation. Yeah, it makes us look like we're talking out both sides of our face on that one. The other thing is, when I get a call from a plaintiff's counsel and they send a demand letter, or they threaten to file a charge or a lawsuit or whatever it may be, if I have a case with really good documentation, that can sometimes make them go away, because I will share that. I will send that over and say, look, we've talked to this individual numerous times over the last year. He's had numerous warnings and nothing has changed. And here's all the documentation of every incident that's happened that led us to this place. There are a lot of attorneys that will talk to their client and say, you know what, I can't do anything for you. And, they'll go away. And that's a good thing, right? You don't want to spend legal fees defending a case. If you've got good documentation, you can avoid that many times. So what is another good thing? So if you are in litigation, another reason that documents matter. So one is they show that this was a real thing, because we did talk about this 6 months ago, 9 months ago. Here's the other thing. If you're in litigation, by the time, that on-site manager or the decision maker has to give a deposition, it's typically 2 to 3 years after the employment decision, because the EEOC process is very slow and long and go on for longer than a year. Some courts, if there's a motion to dismiss or whatnot, it can be another year or two before you get into discovery and depositions. And as we all know, I can't remember what I did last week, let alone what I did 3 years ago and what my basis was in doing that. But when I'm defending a case and I have a witness about to be deposed and I'm prepping them, you know what makes for the easiest prep is when they have write-ups that they did contemporaneous with the decision, getting into the facts, explaining what the decision was based upon. And then they can read that and they can say, oh yeah, I remember this. This is exactly what happened. And then they can give a deposition. So that is a huge piece of this. And frankly, like I said, it creates a credibility bonus, because it makes it look like you didn't make this up. It was important enough. You dealt with it. You had documentation in the time before you had a threatened legal action. And so what that means is it just makes it look like you're telling the truth. It's a credibility bump doing that. So I have a question. One question I have here is, what do we recommend for a good paper trail for doing this, for keeping the documentation? And here's what I would say. One of the things that is awful, and I'll tell you what not to do, then we can start moving into what makes sense. One of the things that do not do is to have people keep their own files.
Oh, I think Courtney's already ordered it. Thank you, though.
When it's keep their own files. And what I mean by that is the manager who has their little notebook or their little file on discipline of everybody, and HR doesn't know about it, nobody else knows about it, and that manager is gone. And then we're talking about a problem employee for someone and their termination decision. We realize we have no documentation. So managers should not keep their own files. as far as what works, I've talked to some clients that really want to see an email sent to HR that documents, I met with such and such on X date, here's what we discussed. And that goes to HR, and HR is responsible for keeping that in the personnel file or wherever they, some file for documentation like that. I think that's fine. I think if you do that, remember that it's not privileged, that whatever you say, there's no attorney-client privilege to that, and that 2-3 years from now, that document's going to be reviewed, given to the other side, and you may get asked about it in a deposition. So if you do that, make sure you're comfortable with that document. I think that's really important here. There are other places I've seen they do write-ups and they put them in the personnel file. They may be handwritten. I've known other places that require the employee to do the write-up, and they make them sit down and write it up to confirm that they understand what's going on, or they sign a different write-up. Whatever works for your organization, as long as it makes it to the personnel file, so that as people change, roles change, everybody knows exactly where to find it. That I think that's really important. And the other reason I'll say why it's really helpful to have it in writing. When we speak, I mean, we're a lot freer with our words. We're looser with our words. We don't give them as much thought as when we put them in writing. And when you ask people to, sit and create a write-up, your supervisor, your manager, they have to give that more thought. And especially if they know that someone may be reading this in 6 months or a year or 2 years, or however long, and you have to choose your words carefully, and you need to try and take emotion out of it, and you need to make sure you're being specific with the facts, and you just get a much better documentation by doing things that way. So what should be documented? Any event or action that meaningfully affects an individual's job performance or suitability as an employee, right? So, clearly, if you're warning somebody, that needs to be documented. If you're dealing with an instance of conduct that if it's repeated, is the individual's going to lose their job, that needs to be documented. You're dealing with more minor issues of insubordination or whatever it may be, or inappropriate conduct in the workplace. These are things that affect that individual's suitability to work for you. That if it continues, that this is the type of thing we're going to terminate this individual for. That needs to be documented. The piece of this that's a little more of a judgment call would be when you're dealing with performance management. And here's what I would say. So as you're first seeing some performance issues with someone, and you want to sit and you're giving some verbal feedback about, Bill, you gave me that presentation 30 minutes before we had to give it to the client. It was full of typos. That wasn't enough time for me to do anything or to meaningfully contribute. We can't have this again, right? That may be one that's important enough that you document in writing. And it may be, if it's a first time, maybe you don't. But by the time you're getting to the second or the third time that you're talking, that better be in writing. That needs to be in writing at that point, because now you're starting to see a trend. Even if the employee is going to improve, that there's an issue here and you need to start documenting it. So even though performance at the very beginning can be a little bit of a judgment call, I think that that starts to move along before the individual has to go to HR, before the manager wants to come and discuss termination, there needs to be a paper trail. So the managers need to understand that as it's at a point where it's like, hey, this is the second or third time I've talked to this individual. This needs to be documented because he or she's not getting it. And we've had to look at this a couple times. All interviews, right? You need absolutely 100% when you're doing interviews, you've got to create a record about that interview. You'll never remember 2 to 3 years ago what the witness told you. Absolutely not. There's no way. You've got to have a write-up of that, either by the witness doing their own statement or the interviewer doing this, writing notes up about what was said. And obviously all conduct issues are going to be at a point that they need to be documented. So, all right. Got a question. What if the employee refuses to sign? So I've got 2 responses. That one is we're going to talk a little bit about how to have better documentation to make it less likely that they're going to refuse to sign, right? By not making it so argumentative and more fact-based. Two, I would say if they refuse to sign, you note refuse to sign. And depending on the conduct in the workplace, that may be a serious issue that that they refuse to accept the counseling. They refuse to accept that this is an issue, and you may have to deal with that fact. But in some workplaces, especially some union workplaces, that is a common thing where you have employees refuse to sign all documentation. And if so, you note RTS, refuse to sign, date it, supervisor's initials, and that's what we do. I've got a question. Can we put things in shared drives? Yes, I would say yes, as long as there's some content control and making sure that only appropriate things are going in there. You know, you do want, as the HR people, you want to have some control that managers aren't putting in there things about that should not be in there, about someone's off-duty conduct that maybe isn't relevant, or their choices on who they date, or their drama of, you need some content control. So I would say that's fine as long as HR is keeping an eye to understand what's in there and removing things that are inappropriate. All right, so, and I do have one question in here saying, well, writing everything up is labor intensive. And my response to that would be, it takes 5 to 10 minutes to do the write-up. I mean, we're not talking about writing a paper. I think it's a 5 to 10 minutes. And it's something that dramatically helps the workplace. It helps your managers when they want to be able to come to you and to terminate someone, that they've taken the time to do that. Because I will share, there are many times where I have a manager who says, I can't deal with this individual anymore, we gotta let him go. We go in, there's no documentation. The same attitude is like, I don't have time to write everything up. I don't have time. And what ends up happening is by the time we get leadership involved, whether it's at the executive level or owners or whatever it may be, and we start talking about what the cost would be if this went into litigation to defend this with no documentation and no ability to prove that we ever spoke to the individual, and we start giving those numbers, I will tell you that almost always the ultimate decision maker, whether it's a president, the CEO, an executive in HR, is almost always going to tell that manager that's like, no, you're not terminating that individual. You screwed up. You didn't do any documentation. You're going to have to figure this out. Companies do not want to be dropping hundreds and hundreds of $1,000s on attorney's fees for the reason that a manager said it's labor intensive. I don't want to have to draft a write-up for everything. And so I just will share that may seem reality in the immediate place, but you have to understand that if you don't do that, you're going to have the highest leaders in your organization looking at the fact you didn't do it eventually and casting a critical eye on your ability to manage people. So I always say you got to err on the side of doing that without a doubt. So, all right. So what are some guidelines for clear and effective documentation? Good documents are honest, right? We're not going to gloss over details. We're going to make sure the relevant details are in that, even if they're somewhat sensitive. You know, and I will give an example of that we did. I had an arbitration involving a workplace where people were harassing an individual over his sexual orientation and making mean and hurtful comments related to that. And the one good thing they did in the write-ups is they didn't shy away from putting what the comments were in the write-ups, right? There's a little bit of a tendency to say, oh, this is going to be embarrassing. I don't want to put this in or even talk about these types of statements. But having those in the write-up showed that these individuals that were eventually terminated, the awful things they said, it made it very clear about that. And even though they grieved their terminations and that went to arbitration, the company in that instance won because we were able to show in basically real time as it went on, all the things that were said, and that no, this wasn't workplace good fun and banter. This was hurtful and in violation of the company's policy. Good documents are contemporaneous. If you try and do documents 3 months later or 6 months later, that's going to come out eventually that you did that, whether it's a document, the metadata showing when the document was created or when the email was sent, that's going to come out and it's going to look like you're making things up if it's not contemporaneous. Good documents are shared on need to know basis. Everyone in the organization doesn't need to know about it, right? No, the people who need to know about the conduct, the individual, HR, the relevant management people, that's really going to be about it. We don't leap to conclusions. We're going to investigate. We don't draft emotionally driven documentation. And again, why would we ever reference someone's protected class, right? There's no reason that should ever be in a write-up. Referencing what their protected class is, or that somehow influences why we're making the decision that we're doing or why we're disciplining. So I've got one question here, and I think this is a really good question. And it's asking, what do you do if the employee wants to record the disciplinary meeting? And my response to that would be, I always advise, do not allow employees to record the disciplinary meeting. This is the company's meeting with the individual. We're not required to be recorded. The individual does not have a right to record the meeting. And there's really no good reason to ever allow them to record the meeting. Because I will say, I've seen instances where someone recorded a meeting and there were some shenanigans with the recording. Parts were omitted or turned to be in a way that it just basically blurred the vocals. So that you couldn't really hear the parts that were more beneficial to the company. And there's no good reason. And you don't want that going online. You don't want that being on Facebook or Instagram or on a web page or any of that other stuff. So there's no reason to ever allow an employee to record a meeting. All right, so this is one I want to talk about for a good example of how to document properly. And this goes back to someone asked about refuse to sign. If we do this first write-up, I gave Tom a reasonable instruction the other day. He defied me and was clearly insubordinate. This type of behavior is unprofessional, right? Tom's not going to sign that. Tom's going to argue that that's not right. It wasn't a reasonable instruction. You asked him to work in the same bad job 2 days in a row. He didn't want to do it. He wasn't insubordinate. That wasn't right. He's going to argue with you all day and night about this one. And so that's not going to be a good write-up. So what do? It's just the facts, right? So you put on this date, and you don't have to 10:40 a.m. You can have in the morning, in the AM shift, in the PM shift, whatever it may be. If you want to put the time in, that's great, but we don't require that level of detail. So I'll read this one. I'm not going to read all these. I have a lot of examples in here to highlight how to document properly. We'd be here all day if I read every single one to you, but this one I will read just to show how it is the facts. So he has in there, I told Tom Carpenter to return to Bay 15 immediately and to continue loading the trailer, right? So we have the facts about what the instruction was. We'll reach our own conclusions about whether it was a reasonable instruction or not. He said, I will not, and stood in the aisle near the time clock with his arms folded. I again told Tom to return to his workstation and unload the trailer. He said, I will not, and continued to stand in the aisle with his arms crossed, right? So again, that's just the facts. He can argue that's not insubordination. We'll argue it is, but we've got the facts in the write-up. I told him he was being insubordinate and that he should consider this a verbal reprimand. Okay, good. It's talking about exactly what happened. And so if you do this write-up here, you don't have to tell people that it was a reasonable instruction and that Tom was clearly insubordinate. They're going to reach that conclusion on their own. If they read this, they're going to say, that's a reasonable instruction. Tom's a jerk. Tom deserves to get that verbal warning. So that would be another example. So another, telling Mary that she's not following safety procedures. Mary's going to sit in and say, what do you mean? I'm the safest employee out there. I'm the one doing all the tag out lockouts. I'm the one out there complying with OSHA. I'm doing this, that. right? She's going to argue with you and she's not going to sign that. But if you put in here exactly what Mary did, well, Mary tried to move a patient without using the appropriate mechanical lift, right? Then you have what the conversation was, all the details. And she says she always does it the right way. Next day you catch her doing it the wrong way again, and you document this and you document this. This is how you deal with this. Similarly, I think Steve had a bogus excuse when he came back from break. Steve's not going to sign that. Steve's going to argue with that. You're going to be arguing back and forth about whether Steve lied or not. So what do we do instead? Right here, we're going to talk about what the facts are. Here's what happened. Steve went on break. He came back late. Steve was asked, why are you coming back late? Steve said he was doing work for someone else's supervisor. We asked that supervisor. The supervisor said, no, he was not, because this individual is homesick today, right? So now we've got it, without any conclusions. We've got in here that, Steve lied to us. He gave an excuse and he clocked in late as a result of that, and lied about it. So I have what happens if they record a meeting without permission. I would say that if it's via Zoom, Teams, or phone, there may be wiretapping issues. I think so it's going to be a state law issue is what I'm basically saying. If someone records a meeting without permission, you have no clue they did it, and it does happen. One thing I'll say is it's usually pretty poor quality because it's a tape recorder or a phone hidden somewhere. If it is good quality, you're going to look at what the state's law is for there and whether they violated it. I know some companies also have policies that if you are ever caught recording a meeting without permission from the individuals there, that's ground for termination. They have that has policies. So I have, all right, this is an interesting question. If you complete a write-up at the time of the event, the facts that you have at the time, but later on you discover more information, should you add that information to the original write-up? No, leave the write-up how it is, but do a subsequent one that's only a few sentences that says, I received a phone call on February 22nd from a customer advising me that Bill Jones had in fact used the same profanity with her that he was accused of using with a different customer 3 days prior, right? So you're just going to add to it, and it's a separate one because you're going to date these, and you don't want it to having been dated to be adding to it after the fact. All right. So here's the cheat sheet, right? Maybe that I use when I'm like basically evaluating someone wants to terminate someone for something. And I'm going to say, and first thing I'm going to say, is there a factual basis? And you know why that is? One, to make sure it's not contrived. One, to make sure that we're acting fair or doing something reasonable. Because when we get into litigation, I mean, I always say part of my job is I'm a storyteller. I'm a storyteller. I have to tell a story to explain why this individual was insubordinate, why this individual was a poor performer, and all the chances we gave this individual, all the coaching we gave, all the warnings, whatever it may be, and they wouldn't change and they didn't care. And at this point, this was the straw that broke the camel's back and why we decided we needed to terminate the individual. And that's a story I tell. And when there's good documentation that allows for that story, you remember, it's going to be, if there's litigation, it's a judge that doesn't know your organization. He doesn't know your management team, or she doesn't know your management team, doesn't know the HR people and how they are, doesn't know that you're good people that try and do the right thing. They don't know. They're hearing from a plaintiff that they have no clue who this individual is, a company they have no clue who this individual is, and their job is to figure out what went on. And it's the same with a jury. And so if I'm able to tell a story and I've got documentation and I can show that we bent over backwards, that tells a story that, you know what, this wasn't retaliation for that complaint that Jane had about it being unsafe to drive that day. This was really about insubordination and defiant conduct and a refusal to act consistent with expectations despite repeated warnings. And that's how you win a case. So that's why there's got to be a story. There's got to be a factual basis. If an employee was terminated or disciplined for a rule, did the employee know? Were they trained on that rule? You can't, it's not right to discipline someone for a rule that you never told them about or trained them on. You got to make sure they're aware of it. It's got to be in the handbook. It's got to be somewhere where they're expected to know. If the employee was previously warned, did they understand the warning? Was there a meeting? Was the individual given anything in writing? Let's make sure they understood the warning. Is the reason for the discipline consistent with performance evaluations, right? If someone turned in one kind of faulty project, but boy, they've been a great employee for a long time and they have great performance ratings for a long time, that's going to look a little odd that this one turning in one assignment late was grounds for termination, especially if it's a 20-year employee or something along those lines. And again, that's something you look at. Are there any public policy issues, right? So I'm always want to know, did the person just file a workers' comp claim? Is the individual have made any complaints about any practices in the workplace? Had they filed a charge or some other legal action recently? These are the questions I'm going to be looking at. So, and like I said before, have we followed the handbook policies? Have others been treated differently under similar circumstances? That's the huge one, to be honest. That one is huge. That if we terminate one person for attendance, but there's other people with similar attendance and we don't discipline them, that's going to be a case you're going to lose virtually every time because it's going to be so hard to prove why we terminated here and why the attendance was so bad for this individual, but it was fine for the other individual who we just simply liked more. That's going to be a bad case. Are there mitigating factors, right? Whether they be legal reasons or whatnot. Is the discipline fair and reasonable? Because we have a story to tell. Have we explored all alternatives? Is the discipline fair? Again, making sure people have talked to HR. That's an important one. So, and again, some people, this is much less frequent now. It used to be 10, 20 years ago that handbooks all had this disciplinary procedure for progressive discipline. And most companies have gone away from that because it's too constricting, right? Because there are a lot of things that will require someone to be terminated immediately. And we're going to always jump to that. And the other thing is it is really hard getting your management people to document performance and to do written warnings and everything. And it's aspirational to have this, but what a lot of companies have found is there's no written warnings, there's no second written warnings, and there's pushback on doing a performance improvement plan or a final warning, right? And so we typically don't include this, but you need to know if this is in your handbook because it may limit your options and restrict you on what you can and can't do. So the right way to document performance. Again, do not sugarcoat unsatisfactory performance, be accurate. And it's hard. We're human beings. It is difficult to say things about an individual that they're not cutting it. It can create conflict in the workplace, hurt feelings. It's hard to sit and say that someone is not a good employee and talk about why they're not, but you absolutely have to do it because what always inevitably happens is I get a management person who can't deal with an employee anymore. Right? I can't deal with this poor performance. He's screwing everything up. She's continually never at work doing the job, whatever it may be, the complaint is. I can't deal with it anymore. It's hurting the business. We got to terminate. And I'll say, hey, send me the performance reviews and the documentation. And then if I see performance reviews that are all meets expectations with no real commentary, oh my gosh, how do you have a performance termination when everything you've told the employees they're doing fine? You've never told them that their performance isn't fine. The employee has no clue what the expectations are. And, you want to terminate now? That's not going to work. That's never going to work. So you've got to be accurate in your performance reviews. And here's what I say. I mean, I do performance reviews for people too. People need to know what the expectations are. It needs to be communicated to them about the things they're doing well, the things they're not doing well. Because how is someone going to improve their performance if they don't even realize what they need to be doing? And so, and it's also a fair review. if you're going to give a review to someone and you're going to point out the positive things, like you have a great attitude, you're so enthusiastic every day at work. I love that. You're a great team player, whatever it may be. But then also point out the negative, which is that, you know what, you have an issue with time management. You keep saving these projects for the last second, so you don't have any time, you don't get input from any of the stakeholders. You're not doing peer review to make sure that this is consistent with other groups and what we want to do. And these presentations are getting turned in at the last second, sometimes with typos, sometimes with outdated data, right? I mean, that's a fair review. You've talked about the positives, great attitude, great teammate in all these ways, poor time management, and that's a fair review. That tells an employee that they need to change what they need to change. You can't sugarcoat the review. And, you can say meets expectations if you have, with the exception of these things that are noted here that there need improvements needed, but you've got to be accurate on this. And in the way I just read that to you, use specific factual examples, right? About specific projects that were turned in late, stakeholders that weren't consulted. If absences and tardies are an issue, have the specific dates in there. Make sure the employee understands what the expectations are. And this last one's important, that if you have had verbal conversations that you haven't documented, put them in the performance review. So at least they're documented in that way. I've spoken with you numerous times, including in April and July of 2023, about this issue about poor time management. It's hit a critical point. Immediate change is necessary if you want to continue working here, or whatever it may be. So I will say, I'll just make sure you can fix things that way. That's something that can be done. And again, I've got a couple questions about people. Is there ever a time, if we have progressive discipline, that we can jump immediately to termination? And the answer would be yes, if that's what your handbook says. That there are some instances that require immediate termination. That I think that's one of the keys to it. So one of the things I would say, we're talking about how to say things well. Like here's some phrases that you need to avoid. Not a cultural fit, right? Bad attitude. Don't use those conclusions. Struggles to work as part of a team, does not collaborate, exhibit. These are better things to say. And I'm not going to read these all to you because you've got the presentation and you can see these things and understand what they are. It's just give specific examples. Don't just say not a team player, uncooperative. Put in there, in every meeting we have, refuses to answer questions, refuses to participate and give feedback to coworkers or to respond to coworkers' requests to help, right? Let's be specific about what the issue is. Acting crazy should never, ever, 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 ever be in a write-up, right? And let's add another 10 to 20, because one, it's an insult. Two, it's a conclusion. Three, the Americans with Disabilities Act creates a cause of action for when someone's perceived as having a disability. And that sure sounds like whoever put this individual acts crazy is perceived as having a mental disability. So again, that should never, ever be in a write-up. Won't make it. Well, I don't know what that's about. That's, that a prediction? And if that's a prediction, then why are we not talking about the specific factual issues and things that go on? Talking about family, whether someone's a family man or a working mom as a basis for a decision. Yeah, that should never happen. And I do recall seeing that a long, long time ago in a write-up about someone was kept because, well, he has a family to support. And you looked at that and you said, well, that is a smoking gun, evidence of discrimination right there. Yeah, a judge or jury is going to have something to say about that when they see that. So these next couple slides are really about making sure you understand that what is in an email will end up in discovery in a lawsuit, and I think a lot of people don't realize that. I realize it because I have to sort through all these emails and produce them in a lawsuit and share them with, the legal group or the general counsel or whoever it may be to say, hey, this manager, just so you know, here's what they're saying in emails about the employee. This is really bad for us. And, now they're talking about maybe having to settle a case because of the specific manager. So you want to do it, but you need to understand whatever you write, someone may be reading that a year later or 2 years later or 3 years later, and you need to make sure you're comfortable with that. So this one, John's messed up again. I'm afraid to talk to him because every time he makes a mistake, he tells me I'm discriminating against him. Enough is enough. Can we get rid of him? Please. He's crazy. Again, crazy, right? That's going to be a problem right there. But then we've got this about, we'll put him on a PIP and then we'll just fail. We'll make it something he can't even pass and we'll terminate him at the time when he doesn't, successfully complete it, right? This is evidence of pretext. This is evidence that the real reason for the termination of him being on a PIP and being terminated for that was not the real reason he was terminated. It was this supervisor's concern that he's crazy and because he keeps complaining that he's being discriminated against. That's a problem. That is a big problem. That will help you lose a lawsuit.
Hey, Gary,
yeah.
I just want to interject real quickly here. I'm unfortunately the time police around here, and we are coming up to our next session. So I know you've got several more slides to get to. We'll make the commitment to getting the slides out to the attendees because you were so gracious in answering so many questions throughout this. But I'm not sure we're going to be able to get to quite every one of them here leading up to the next session. So I wanted to give you the opportunity to say, is there anything in the last 4, 5, 6 slides here that you think is a great conclusory statement or that you really want to get across to the group here? And then I've got one question for you before we move on.
Yeah, I would say, because there's been questions about doing a good PIP, this one slide right here, if we've got time for one slide, let's do it.
Yeah.
Okay. And so I would say, here are the things, like if I spend a lot of time rewriting for clients, it's performance improvement plans. And it's because they tend to be not written in factually specific ways. And so you need to make sure your performance improvement plan has specific bullet points. If the issue is poor time management, we talk about this project on X date, you didn't get stakeholder input. You turned it in late with typos. You give all those 3 to 4 examples, whatever it may be. And then you say the expectation, you will turn projects in 48 hours in advance with, to allow for time for stakeholder input, to allow for proofreading and to allow for everyone to sign off on it, right? You give them very specific deliverables that you'll know whether they met or they didn't meet. It's got to be clear. It's got to be understandable, specific, so everybody knows whether it was was met or not. And that's how they have to be drafted. It can't be vague goals about work collaboratively with everybody. Well, what does that mean? Right? We don't know what that means. So,
No.
But no, that's the one slide I wanted to get to. So
it's super helpful. And there were a ton of PIP questions and just a ton of engagement generally. So I want to thank you, Gary, for being open to having the back and forth and the interaction. I think that's a great way to optimize our time together. One question I have, and you brought this up a few times throughout, kind of made the statement of that'll lose you a lawsuit, right? And I think that what we're all talking about ways is to mitigate employer risk today at the end of the day. You defend employers, litigate on these issues every day. When employers aren't successful, when your employers aren't successful that you defend, what are the common themes as to why? I was just wondering if or is there a couple things that stand out in your word? And I know that there's going to be specifics with each case, but is there anything you would share with this team to say like, hey, these are the things that I see over and over. When I can't win, here's why.
Yep. I'll give you 2 things.
Okay.
2 things. All right. Number 1 would be you're not treating everybody the same.
Mm-hmm.
We terminated this person because his sales numbers were this poor, whatever it may be. Then we look at the whole sales group and we see other people with comparable numbers.
Mm-hmm.
And there's an explanation for why that individual wasn't terminated, but it's an explanation that could lead to people maybe agreeing or disagreeing, right? It's not rock solid. So it's treating terminating someone for attendance when there are other people with comparable attendance, right?
Sure.
Those are big ones. The second one is in this world of ESI, electronically stored information
Yeah.
discovery. So here's what happens. Like I get requests and we sort through IMs. We look at IMs, we look at Teams messages, we'll look at emails between specific individuals in a specific date range. And it frequently happens that we see Teams messages that contradict what our managers are telling us happened.
Yeah.
And they're saying things inconsistent with that, and it makes it look like they're lying, or it contradicts the facts as we know it. And that almost always leads to a discussion with leadership that says, before we even produce that, it's like, we got to settle this.
Great call outs. Great call outs. Yeah, with all the different ways to communicate, making sure that those communications are consistent across all platforms is definitely important. So Gary, can't thank you enough. And I know that this is, and thank you to the to all the attendees for the great interaction and the great engagement. We'll now take a short break. We're going to reconvene for session 3 at 10:50 a.m. Central, 11:50 Eastern. Let's keep the great engagement and questions coming. And once again, thank you so much to Gary from Corals and Brady. Can't thank you enough. All right, we'll see y'all shortly.